Welcome everyone to docket 9810 CE 100, the application for a certificate of public convenience and necessity of Portage Solar LLC to construct a solar electric generation facility in the towns of Grant and Plover, Portage County, Wisconsin. This is Mike Newmark, the administrative law judge for the PSC, and we're here on Zoom for this. First of all, the party hearing session. We'll be holding public hearing sessions to take public comments in this case at 2 p.m. and 6 p.m. And it'll be the same connection information to get to those hearings as this one. So those have been provided in our notice of hearing, made available to the public. And so at this point, the party hearing session will be hearing from parties and commission staff, taking evidence from those entities, and then in the afternoon we'll be doing the public session for public comment. We're also accepting public comments in writing. Those can be filed no later than Friday, December 2nd, by the end of the day, the very end, like 11:59. That can be accepted through the commission's internet site and by US mail. So the details of that are also on the hearing, on the notice, which you can see on the screen. With that, I'm just gonna switch over for appearances for the parties. So I guess it's just off the record. I think we just off the record. Just wanted to confirm with, I think, so we're off the record. So Lynn, I think, is that your phone buzzing?
I'm trying to put the do not disturb. I'm sorry, I forgot to do that.
Okay, yeah, go ahead. That's fine. Okay, well, we're off the record. So I just wanted to confirm with Portage Solar, the email exchange. I think Attorney Callisto had mentioned that the applicant wished to take the Jenny Monson Miller contact off the service list, claim that because it's the utility primary address, needs to remain on the list, but the applicant has the option of changing that contact detail by using the commission's website form. So I just wanted to make sure, are we gonna see an update of that, or should I leave the list as it is?
Your Honor, I believe we changed that yesterday afternoon late, removed Miss Monson Miller and made Amber Miller the utility primary contact.
Okay, and is it going to be a personal email then?
No, it should be the same information that we have right now for Amber Miller. Just going to move her up to the primary contact.
Okay, so you just have her as the. Okay, just so you know, it's up to you, but just leaving that option open, and you could have possibly just a generic email so that you don't have to, it doesn't get to, you can direct it to whoever you want to internally, but you don't have to change it based on the person. Okay, so are we good to go with the Lynn? You all set?
We are, but before we go back, is there a name identified with the Dane County Conservation League, or is somebody not going to? Are they not a party?
That's not a party. So
okay, I just want to be sure. Thank you.
We're just observing right now. Yeah. Okay, so let's get back on the record then. We're just going to do appearances. So we'll start. We're just going to go down the list as we have it here. So let's just ask for who's representing Portage Solar.
Your Honor, this is Eric Callisto with Michael Best and Friedrich, outside counsel for Portage Solar. With me today is my colleague, Alex Peterson, also with Michael Best and Friedrich. And then on behalf of the applicant, we have Amber Miller, Ellie DeBleek, Brett Schneider, and Andrew Larson. Ellie, Brett, and Andrew are all witnesses in the case. And we also have John Wader from Stantec, who's also a witness.
Okay, great, thank you. All right, Commission, Public Service Commission.
Stephanie Bedford, Assistant General Counsel, appearing on behalf of the Public Service Commission. With me today is Assistant General Counsel Zachary Peters.
Okay. And Renew Wisconsin. Need to unmute. Let's see, you're there looking for it.
Good morning, Michael Vickerman with Renew Wisconsin.
All right, great, thank you. Okay, so yes, so that services, I'll make the adjustment to the utility primary address, and we'll just need a notice of appearance from Attorney Peterson, and then I can put that attorney's information into the list. So I think that's all we need for there. Let's move on to the offered evidence list. I did want to mention before we get started with that, I didn't see any cross for witnesses. Is that still the case?
That is still the case for Portage Solar, Your Honor. Subject to hearing if there's any certiorari rebuttal.
Okay, yes, of course. Any other parties have questions at this time for witnesses?
No.
No. Okay. All right. So let me, I guess the next logical thing to ask, do we have any rebuttal for witnesses? Any additional statements that they wish to make on the stand?
Yes, Your Honor. For Portage Solar, witness Schneider and witness Wader both have certiorari rebuttal.
Okay. Anyone else? I guess just staff and Renew. No? Okay. So I think what we can do at this point is, I mean, I can excuse the remaining witnesses other than Schneider and Wader. So let's, I don't know if we're on the record anymore, actually. Let's get on. Make sure we're on.
Oh, we were on.
Oh, we are. Okay, that's fine. I thought I said, okay, that's fine. So that's good. So we can excuse all witnesses but Schneider and Wader. And it's up to those parties whether they wish to call those witnesses to verify their testimony live or file an affidavit. And I know there was one witness that had a time constraint, so I'm just trying to do this earlier in the day here. Didn't know if there are any questions about the comments I had raised in the offered evidence list. That's the list I sent.
Your Honor, this is Eric Callisto. I do have just a clarifying question on your marginal note on the exhibit application. I understand that you want us to refile it with live links. It has been filed, but the links are not live. Is that what your request is?
Yes.
Thank you. We'll get that done.
Okay, and make sure that the confidential links should be live as well. You won't be able to open them off our internal connections at the PSC, or you have to be logged in as a PSC employee, but any confidential should be linked. Those links should be live. So if you need assistance on creating those links, you can email me. I can give you the template for that.
Understood.
But I think we've done this before, so I think you probably have that information.
And Your Honor, I do have I'm sorry, go ahead, Michael. Sorry.
I had a question on your comment. What does create OCR copy mean?
Okay, so it's the text of that document should be searchable, and right as of now, yeah, we can't. It's not searchable. So as you're making the PDF, there should be a opportunity to select saving it as an OCR document. It's just the kind of the acronym for making the document text searchable. And I believe you've done that before. I think you have had documents that have met that requirement before, so it might have just been an oversight.
I'm not sure. Actually, it's perhaps our attorneys in another case have that capability, but basically, this what you see there is a screenshot. And that's what I can do.
I see. Okay. Well, can you check in with staff at Renew and see? I can just do your best efforts to turn that to OCR. I think it's just the requirement we have that that we can search these documents when they get on earth, or if we're looking at them, you know, a massive amount of documents, it's good to have these things be text searchable. It's easier to find them that way. I can waive that if it's not something you're capable of doing, but I just do your best and try to figure that out, because I think I think Renew does participate enough that it should be able to meet that requirement. So let me know if you're having trouble. We can address it.
Okay.
Okay.
And Your Honor, this is Eric Callisto. This may be the appropriate spot to raise.
We're not
an issue I raised.
We're not hearing you. Sorry.
Can you hear me now?
Yep. There you go.
This may be the right time to raise an issue that I mentioned in the email yesterday to the parties and to you. We would like to leave the record open to a reasonable date, subject obviously to hearing about objections on that, to get.
We're gonna have to.
Sorry.
We're gonna have to interrupt again. It's not coming in clear.
Let me try it one more time. Get closer to the speaker. So we have a
Nope, it's still
request to have the record remain open to get a late filed exhibit in,
We'll have to
specifically.
Let's start over. It's getting better and worse. So I don't know if you're doing something and then maybe you're leaning back, or I'm not sure why it's not working.
Let me do this. I'm not sure either, Your Honor. Let me call in if that's okay.
That's fine. We can do that. So let's
Thank
go
you.
for it. Well, we're off the record. So Stephanie, are we expecting to verify that witness's testimony who has a time constraint? We're expecting
Yes,
that.
that's DNR witness Samantha Whitens. She has a conflict beginning at 10:30. So if we can get her on
Okay,
and off before 10:30, that would be optimal.
we'll do her first then, but let's just get this last item settled.
Sure. Okay, Attorney Callisto, I think you've gotten your connection through. And you're muted at this point. You'll need to press *6 to unmute.
Can you hear me now?
Yes, much better. Thank you.
All right. Sorry about that.
Why don't we start at the top about the motion for leaving the record open?
Thank you. So this is a request of Portage Solar to leave the record open to a reasonable date. We would suggest January 6th to try and get a late filed exhibit, specifically a joint development agreement. As the record reflects, Portage Solar has been in active negotiations with the county and the two municipalities that are part of the project in getting to a joint development agreement. We've had a number of iterations back and forth. I do believe we're close. We're just not quite there. And we would like to get this into the record if possible. So we're open, obviously, to the latest date that the parties in the ALJ are agreeable to. I don't think the JDA is going to be controversial or different in kind than anybody else has seen who's part of this case right now. The brief is due on January 10th, the first brief. So I'm proposing January 6th or January 9th possibly to allow this to be filed if we can get it done by then.
Mm-hmm. Okay. Any response from parties and staff? I'm not hearing anything. Okay, so I don't have a problem with receiving exhibit late, exhibit after the hearing. I think the best process though would be to, if you could file it along with a motion to request to the addition of supplemental evidence, just in case, because people haven't seen that document yet. They'll give them a chance to review it and decide whether they have any objections. Otherwise, that motion could be filed with a stipulation, or at least the representation that all parties and staff affirmatively agree to the receipt of that document. Then I'll know that there's no process needed to accept that document, any further process. And so if it goes in with a motion with a stipulation or that representation, it'll be accepted, received immediately. If there's a motion without representation or stipulation, there'll be a 3-day window where parties and staff can respond, and then we can move forward with any subsequent process. That's just the cleanest way to do that, because we don't have the document in front of us. I don't expect that to be a problem. And really I can say, of course, it'd be inopportune to file, the later it's filed, the harder it is to deal with. But if we use that motion process, there really is no specific date that I need to set. It'll just be whether the motion will be granted or not. One of those reasons may be just it comes in too late for a supplemental process to take place, if any would be needed. So I'd expect if it does get filed in the date you suggest, all should go well. So we'll do your best efforts to get that in on that date. Otherwise, if you file the motion process, we don't really need to set a deadline here.
Understood. Thank you.
Yeah, and if you could file the document along with an affidavit as well, verifying the exhibit, that's also part of our process too.
Thank you.
All right, so I think we've done so offered evidence list. One more question. Are there any changes, corrections we need to make to the list itself, the documents listed here? Okay, not hearing that. So, and we'll be expecting, I assume, the data request response exhibit from staff. Is that correct?
Yes, that's correct.
Okay, and then the public comment exhibit will be filed if we have more than 5 public comments made during the comment period. So far, there's 3 on file. So at this time, we may not need to do that, but still time for comments to come in. All right, so I think we're going to skip to our witness with a time constraint and have that person verify testimony. Someone just joined us here.
The commission calls Samantha Whitens to the stand.
Okay, perfect. So let me swear you in. Raise your right hand. And do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, great. Go ahead.
Please state your name for the record.
Samantha Whitens.
What is your position at the Wisconsin Department of Natural Resources?
I am a water resources engineer.
Did you file or cause to be filed direct testimony and rebuttal testimony in this docket?
Yes, I did.
Are the statements and representations in the testimony you filed in this case true and correct?
Yes,
Do you have any additions or modifications to your testimony at this time?
I do not.
Your Honor, the witness is available for cross-examination.
All right. So let me just note that I'll receive all the documents on the offered evidence list into the record, subject to verification. And are there any questions for this witness? Okay, I'm not seeing any, so thanks very much. You're excused.
Thank you.
All right, let's move. So any other witnesses have a time constraint? All right, so let's move back to the applicant. So let's call our first applicant witness.
Portage Solar calls Andrew Larson to the stand.
Okay. Find you on my screen here. Larger group than I expected. So
I'll just speak up so I pop up the top of your list there.
there we go. Yes, if I just asked you to raise your right hand, that would have that would have done it. All right, great. So do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes,
Okay, go ahead.
Mr. Larson, did you cause to be filed direct and rebuttal testimony in one exhibit in this case?
yes,
And if asked those same questions, would you give the same answers today?
yes,
Any changes or modifications to your testimony of the exhibit?
no,
And are those questions and answers in the exhibit true and accurate to the best of your knowledge?
yes,
The witness is available for cross.
Okay, any questions? No? All right, thanks. You're excused.
Portage Solar calls Ellie DeBleek to the stand.
All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Ms. DeBleek, did you cause to be filed direct and rebuttal testimony as well as 3 exhibits in this case?
Yes.
And if asked those same questions today, would you provide the same answers?
Yes.
Do you have any changes or modifications to your testimony or exhibits?
No.
And is the testimony and are the 3 exhibits you caused to be filed true and accurate to the best of your knowledge and understanding?
Yes.
The witness is available for cross.
Okay, so thanks for that. I only see 2 exhibits on my list, so maybe I've missed something here.
Yes, Your Honor.
Your Honor, I think, I'm sorry, go ahead, Alex.
Sorry, Eric. Yeah, I think the 3rd exhibit, Your Honor, is the actual application itself, the CPCN application.
Oh, okay. All right. Well, that'll be duplicative of the application exhibit, but since it's already been filed, I'll receive that as well. So let me make that adjustment. That's
Your Honor, and this is Eric Callisto, and just for clarity going forward, I assume that I in the past have made the application an exhibit of a witness, which is what we did in this case. If the preference is not to do that, then obviously we won't.
yeah, I'm still not. Do you have a PSC number? And we can go off the record for this. Do you have a PSC number for that?
453313. And this is the one that we're going to refile with the live links.
Oh, I see. Oh, okay. So let me just display that here. So this is our kind of internal view of the filing. So it is described as the application exhibit, if you can see that there. So I was just hoping that there'd be an update to that. So I'm not sure if that was that then labeled differently? So yeah, so it's still the Portage Solar application. So it wasn't identified as a DeBleek 3 as far as I can see.
That's correct. Yeah, that was my mistake.
Okay.
I historically have not named it as an exhibit of a witness, but I have put it in through a witness.
Oh, okay. Okay. So just to clarify, we were just asking the witnesses whether the witness had offered a DeBleek 3, and that was affirmed and verified by the witness. But we just want to correct that there are only 2 exhibits marked with the DeBleek identifier. So there really isn't a DeBleek 3. So if we could get on the record and just have the witness clarify that, can you do that, Attorney Peterson?
Yes, Your Honor.
Okay, great. Let's get on the record. So we do have a clarification. Go ahead, Attorney Peterson.
Ms. DeBleek, to clarify, did you file 2 exhibits rather than 3 exhibits in this case?
Yes.
Thank you. The witness is available for cross.
Okay, so witness DeBleek, so you did file documents, exhibits marked DeBleek 1 and 2, is that correct?
Yes, that's correct.
And there is no DeBleek 3, is that correct?
That is correct.
Okay, thank you. All right, so yes, cross. Let's ask any cross questions for this witness. All right, seeing none, we can move on. Thanks very much. You're excused.
Portage Solar calls Brett Schneider to the stand.
All right, see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead.
Mr. Schneider, did you cause to be filed direct and rebuttal testimony in one exhibit in this case?
Yes.
And if asked the same questions, would you give the same answers today?
Yes.
Do you have any changes or modifications to your questions and answers?
No.
And are those questions and answers in the exhibit true and accurate to the best of your knowledge?
Yes.
Mr. Schneider, have you reviewed the rebuttal filed in this case?
Yes, I have.
And do you have sir rebuttal you would like to provide in response to that sir rebuttal?
Yes.
Mr. Schneider, have you reviewed the sir rebuttal testimony filed by Commission Witness William Taylor?
Yes, I have.
At page 3 of his sir rebuttal testimony, Witness Taylor recommends that the project's capacity refer to the project's overall generation nameplate capacity rather than the project's capacity at the point of interconnection. Do you agree with this recommendation?
No. Witness Taylor expresses concern that if the project's approved capacity amount is measured at the point of interconnection, Portage Solar might construct the project's facilities in excess of what has been proposed and discussed in this docket. However, explained at page 3 of my direct testimony, page 2 of my rebuttal testimony, and pages 17 and 21 of Portage Solar's CPCN application, Portage Solar has clearly stated throughout the CPCN process that the project's proposed capacity is 250 megawatts at the point of interconnection. The application specifically notes at page 21 that the primary area is designed at 252 megawatts alternating current, and that generation will be limited to 250 megawatts at the point of interconnection. Mr. Taylor's first objection to measuring capacity at the point of interconnection suggests that the modification to the order points would result in construction of facilities in excess of what Portage Solar has applied for and what the record supports. That is simply not accurate. Portage Solar was explicit on this issue throughout the application process. Mr. Taylor's second concern is conjecture. He states without any supporting facts that a difference between nameplate capacity and capacity at the point of interconnection, quote, could result in additional impacts to safety, reliability, and the environment that are not discussed in the record of this docket, end quote. Not only was the project designed with a small amount of extra nameplate capacity in mind, all of the work that was done to survey the site also anticipated this and accounted for it. It is engineering reality that there will be a loss of energy from the time it gets generated at the solar panels to when it gets delivered to the point of interconnection. That is the case for every project already approved by the Commission. What Portage Solar has proposed is to clarify this issue and to allow Portage Solar to take full advantage of its 250 megawatt interconnection request with MISO. As with prior solar projects approved by this Commission, Portage Solar will comply with all the traditional order points that limit the area upon which the project may be built and how it may be built. But it makes no sense to limit the megawatts at the nameplate capacity of the generation, particularly when the project also has a battery energy storage system. The battery's ability to provide power and capacity on demand demonstrates that the nameplate capacity of the generation is simply not the best measure of the size of this project. Mr. Taylor's concerns are not warranted, and the modifications proposed to the order points in my rebuttal testimony should be adopted by the commission.
Does this conclude your additional testimony?
Yes.
The witness is available for cross.
Okay, any questions? No questions? Well, I did have a question based on that Sir rebuttal, witness Schneider. Now I haven't verified this to the extent that I probably should have before asking this, but I wasn't really expecting to ask this before. But my understanding about the staff's proposed order condition is that it's been the standard language throughout the solar project cases to use that language about nameplate capacity. And I'm just wondering if there's a difference that you are aware of between this project and past projects that would warrant adjusting that standard language.
I'm not aware of other past projects and been too involved in those.
I'm sorry, you faded out there.
I haven't been super involved in past projects, so I'm not aware of that language.
Okay. All right. So any other questions? No, any redirect?
No, Your Honor.
All right. Okay, thanks very much. You're excused.
Thanks.
Portage Solar calls John.
You're cutting out again, Attorney Callisto. Maybe get that phone
All
closer.
right. Portage Solar calls John Wader.
All right. Witness Wader, raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, go ahead.
Mr. Wader, did you cause to be filed direct and rebuttal testimony and 3 exhibits in this case?
Yes.
And if asked the same questions, would you give the same answers today?
Yes.
And do you have any changes or modifications to your testimony or exhibits?
No.
And is your testimony and exhibits true and accurate to the best of your knowledge?
Yes.
Mr. Wader, have you reviewed the Sir rebuttal filed in this case?
Yes.
And do you have Sir rebuttal you would like to provide in response to that Sir rebuttal?
Yes.
Mr. Wader, have you reviewed the Sir rebuttal testimony filed by Wisconsin Department of Natural Resources witness Stacy Rowe?
Yes, I have.
Do you agree with Ms. Rowe's recommendation at page 2 of her Sir rebuttal testimony that non-native fescue plant species be removed from Portage Solar's planned seed mixes for the project?
No. The 2 fescue species included in the revised low-grow graminoid seed mix for PV panel areas, nodding fescue and red fescue, are considered native and native non-native, or both, respectively, according to the U.S. Department of Agricultural Plant Database. Both is a nativeness category for circumpolar species found around the Northern Hemisphere, and is a category that includes both native and non-native species. Red and nodding fescue were chosen specifically due to their extremely high germination and establishment rates in sandy, nutrient-poor agricultural soils, and specifically the central sands region of Wisconsin. Removing these 2 species from Portage Solar's seed mixes would jeopardize Portage Solar's ability to adequately revegetate the project area post-construction, and would increase the likelihood of the establishment of aggressive volunteer weedy species within the array blocks. I have worked on multiple utility-scale solar and electrical transmission projects in Wisconsin that included these 2 fescue species in their restoration and revegetation plans. Additionally, Portage Solar revised the low-grow graminoid seed mix following the May 6, 2022 on-site meeting with DNR staff. The revisions following this meeting acknowledged WDNR's concerns over non-native warm season fescues by removing hard fescue from the low-grow graminoid seed mix. Hard fescue was the only non-native fescue species included in the original vegetation management plan.
Do you have any comments on witness Rowe's recommendation at page 2 of her Sir rebuttal testimony that POA non-native Compressa Protensis trivialis grass species be removed from Portage Solar's planned seed mixes for the project?
And if
Well,
you could read a little, oh, excuse me, if you could read a little slower, that would help a lot.
Okay.
Thank you.
While Portage Solar has no issue with removing non-native Hoa, compressa, pratensis, trivialis species from its seed mixes, in doing so, it would need to significantly increase the rate of upland bent grass in its seed mixes to compensate for the removal of the non-native Hoa species. This increase in seed rate of upland bent grass is required to maintain the seed density of the proposed low-grow graminoid seed mix.
Have you reviewed the surrebuttal testimony filed by WDNR witness Cherie Rademacher?
Yes, I have.
At page 2 of her surrebuttal testimony, witness Rademacher argues that Portage Solar should leave all vegetative buffers in place. But if disturbance to vegetative buffers cannot be avoided, then Portage Solar should limit such disturbance to after the construction phase of the project when practicable. Do you have any comments on this testimony?
Yes. While Portage Solar will attempt to leave vegetative buffers in place where practicable, the project may require removal of certain vegetative buffers to accommodate construction traffic, prevent panel shading, and provide a safe workspace during construction. All field verified wetlands and waterways, along with an approximately 20-foot buffer, will have perimeter best management practices installed prior to the start of ground disturbing activities. Likewise, if all or a portion of existing vegetative buffers around wetlands and waterways are removed, appropriate perimeter best management practices will be installed to prevent the migration of sediment into these resources. The areas where vegetative buffers are removed in part or entirely will be restored according to the project vegetation management plan. Portage Solar has no objection to an order point that requires that during and after construction, existing vegetative buffers not be disturbed to the extent practicable. Portage Solar will protect existing vegetative buffers wherever it will not impact the project. The proposed order point should read as follows, quote, Portage Solar shall leave existing vegetative buffers in place where practicable, end quote.
Mr. Wader, have you reviewed the surrebuttal testimony filed by Commission witness William Taylor?
Yes, I have.
At page 3 of his surrebuttal testimony, witness Taylor recommends that the project's capacity refer to the project's overall generation nameplate capacity rather than the project's capacity at the point of interconnection, because using the point of interconnection could result in additional impacts to safety, reliability, and the environment. How do you respond?
As the primary engineering and environmental consultant on this project, Stantec did a thorough analysis of the project area and reviewed all environmental and engineering issues associated with a 252 megawatt alternating current nameplate capacity project interconnecting at 250 megawatts. Mr. Taylor's testimony, to the extent it suggests the project was not evaluated or designed with the capacities in mind, is not accurate. The CPCN application also addressed this issue and provided substantial information showing the requested capacities and footprint of the project. The Commission should not be concerned that approving the project at 250 megawatts at the point of interconnection will result in unanalyzed impacts to safety, reliability, or the environment.
This concludes your additional testimony.
Yes.
The witness is available for cross.
Okay, any questions? No. All right, I just wanted to follow up with my questions for prior witness. So witness Wader, just curious, like I mentioned before, the language in the regarding interconnection nameplate capacity, to the best of my knowledge, was standard language used in past solar project final decisions from the Commission. Do you know of any differences between those projects and this one that would justify the change in that order point?
Not that I'm aware.
Okay, so I was just curious because now it's coming to my attention maybe the tension here the interconnection is designed at 250 megawatts and the project is designed at 252 megawatts. Is that correct?
Correct.
Okay, so discrepancy, and so is the project is not, your Portage Solar is not, has no intention to design a project greater than 252 megawatts. Is that correct?
Correct.
Okay, so is your understanding the fact that and I guess the problem is there may be line losses between the designed capacity and the capacity at interconnection?
I'm not an engineer, so I would defer to Brett Schneider with that question, but that's what I believe.
That's what he stated. Okay.
Yes.
All right. Well, I don't know what else to how else to clarify this further, but I guess that seems to be where the argument is. But 252 is the maximum design capacity of the project. That's my understanding now after listening to your testimony. Okay.
Your Honor, I can't testify obviously, but I can, if it's helpful to the court, I can give an explanation of this issue. And that may facilitate additional questions from you.
Well, yeah, I'm not sure in terms of the back and forth between the applicant and staff, or what clarification did you want to make? What's the topic of your clarification?
Sure, the clarification, the reason that we are doing this is to reflect what I believe is the reality of how, and what more importantly, what Portage Solar believes is the reality of the disconnect in all projects between what's generated at the project and what gets delivered, as you know.
Stop you there, and just if you have a witness that can explain that, you might be able to ask.
I'll call Mr. Schneider back to the stand if that's okay.
Okay, yeah, let's do that. And before we leave with witness Wade here, any Whiter, right? Is there any questions for him from parties? I don't remember if I asked that before. Parties and staff.
No.
No. Okay. All right. Let's have witness Schneider back. Just remember you're under oath.
Yes.
Mr. Schneider, you're aware that Portage Solar is seeking approval for to build this project at 250 megawatts at the point of interconnection, correct?
Correct.
And is it accurate that to do that, Portage Solar wants to build the project at 252 megawatts AC?
Correct.
Generally, can you explain why there's a difference between the amount of megawatts that are generated by a solar project in the field and the amount of megawatts that get delivered to the point of interconnection?
Yes. Generally, we we have line losses between our, let's say the high side, the high voltage side of the substation where we produce our nameplate capacity, where it runs through the Gentie line. It could be a certain distance where the electrons dissipate, and we have some losses on the line where we can only actually get 250 megawatts at the point of interconnection.
And is the phenomenon that you just described, is that a component of all large solar projects?
Yes.
And so is it accurate that for Portage Solar to get the full benefit of a 250 megawatt AC point of interconnection approval from MISO, it has to build the project larger in the field?
Yes.
No further questions.
Okay. And just to nail this down completely, so the maximum capacity that's being proposed in the application before the point of interconnection is 252 megawatts. Is that correct?
Yes,
Okay, and so Portage Solar has no intention of building any capacity above 252 megawatts for this project.
not at this time, no.
Okay, but any capacity above 252 megawatts, well, I guess we don't know that for sure, huh? What process do you believe would be required if the Portage Solar was going to build a project, was going to add more than 252 megawatts to the project?
I think there's some more engineering studies and design to be had, whether there's losses on the line, but we feel that, this general 2 extra megawatts would accommodate for us being able to put the full 250 megawatts on at the point of interconnection.
Okay. And you mentioned that this is something that occurs in other projects.
Yeah, it occurs on every project, since depending on the length of what's called the gen tie line between the project and the point of interconnection, there's a certain amount of losses between. So if it's a longer line, multiple miles long, then there'd be more losses, or we'd have to build larger. Or if it's right next to the point of interconnection, there'd be less losses.
Okay. And is in your experience, have you built projects in that manner in Wisconsin?
I have not in Wisconsin. I have in other states.
Okay.
Yes.
All right. Thanks. Okay.
Yep.
Any follow-up questions from parties and staff? No. How about redirect?
No, Your Honor.
All right. Great. Okay. So you're excused, witness Schneider. I believe we didn't specifically excuse the previous witness Waiter at this point, but I don't think there are any questions for that witness anymore, so we can excuse that witness too. And do we have, is that the balance of applicants' witnesses?
Portage Solar rest, Your Honor.
All right. So we'll move on to renew. See Michael Vickerman there, so raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right. So witness Vickerman, did you file direct, surrebuttal, and 3 exhibits labeled Vickerman 1, 2, 3, and 4? I'm sorry. Yeah, 1, 2, 3, and 4.
Yes, I submitted direct, surrebuttal, and 4 exhibits.
Okay. And are those filings complete and correct to the best of your knowledge?
Yes.
And do you have any testimony to add?
No.
All right. Any questions for this witness? No, not seeing any. Okay. Thanks very much. You're excused.
Thank you, Your Honor.
All right. And we'll turn to commission staff for the balance of staff witnesses.
Your Honor, the commission calls Adam Engwell to the stand.
Okay. Raise your right hand. Maybe I could spot you. Oh, there you go. You got to turn your screen on. Not seeing. Okay. Perfect. All right, great. So raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record.
Environmental Affairs Coordinator, Supervisor.
And sorry, I want to ask you to state your name for the record and not yet your position.
Adam Engwell,
And now, what is your position at the Public Service Commission of Wisconsin?
Environmental Affairs Coordinator, Supervisor.
Did you file or cause to be filed direct testimony in this docket?
I did.
Are the statements and representations in the testimony you filed in this case true and correct?
Yes. Yes.
Do you have any additions or modifications to your testimony at this time?
I do not.
Your Honor, the witness is available for cross-examination.
Okay, any questions? Not seeing any. All right, thanks very much. You're excused.
Thank you.
Commission calls Jerry Rademacher to the stand.
There you are. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
Yes.
Okay.
Please state your name for the record.
Jerry Rademacher.
And what is your position at the Wisconsin Department of Natural Resources?
I am a water management specialist in the DNR's Office of Energy.
Did you file or cause to be filed direct and surrebuttal testimony in this docket?
Yes.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony or just your testimony at this time?
I do not.
Did you hear the testimony of John Wader here today?
Yes.
And does what he stated about vegetative buffers change your position in your testimony?
No.
Your Honor, the witness is available for cross-examination.
Okay, any questions? No questions. All right, thank you very much. You're excused.
The commission calls Stacy Rowe to the stand.
Hi there, raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth.
I do.
Okay, go ahead.
Please state your name for the record.
Stacy Rowe.
And what is your position at the Wisconsin Department of Natural Resources?
I am the Endangered Resources Utility and Transportation Liaison.
And did you file or cause to be filed direct and surrebuttal testimony in this docket?
Yes, I did.
Are the statements and representations in the testimony and exhibits that you filed in this case true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
And did you hear the testimony of John Wader here today?
Yes, I did.
Does what he stated about the removal of certain species from the planned seed mix change your position on that subject?
No, my position still stands as I stated in my original testimony in Surrebo.
Thank you. Your Honor, the witness is available for cross-examination.
All right, questions? No, not seeing any. Okay, thank you. You're excused.
Thank you.
The commission calls William Taylor to the stand.
There you are. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead.
Please state your name for the record.
William Taylor.
And what is your position at the Public Service Commission of Wisconsin?
Public Service Engineer.
And did you file or cause to be filed direct and surrebuttal testimony in this docket?
Yes.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony at this time?
No.
Did you hear the testimony of John Wader and Brett Schneider today?
Yes.
Would the order conditions as you propose them limit the nameplate capacity of the project as proposed in the application?
No.
Does anything that those witnesses stated change your position in your original testimony?
No.
Thank you. The witness is available for cross-examination. All right, any questions?
Your Honor, I do have a little follow-up from Mr. Taylor based upon based upon what he just said on the record.
Sure, go ahead.
Mr. Taylor, I want to make sure I understand what your answer just was in response to the question from your attorney. Am I accurate that you're representing your preferred order point language on the capacity of the project as not limiting it to 250 megawatts nameplate?
I don't believe that my testimony or my position limits the capacity listed in the application, which would be 250 is the nameplate capacity, or 252 with the extra inverter.
So I want to make sure I understand what you just said. Are you okay with an order point that would specifically allow this project to be built at 252 megawatts AC?
I do believe that that could be reasonable. I stand by my rebuttal testimony that limiting the capacity at the point of interconnection would not set a limit at that 250 or 252.
So I understand that you want to have a limit both for nameplate capacity. Strike that. I understand what you're saying. Then you want a limit at nameplate capacity, correct?
That's correct.
And if Portage Solar agrees to not build this project any greater than 252 megawatts AC nameplate capacity, you would have no objection to that?
Yes, and I want to make clear, still standing by the rebuttal, that we don't want to have the at the point of interconnection in that order condition.
What is your objection to a 250 megawatt point of interconnection limit in addition to a nameplate generating capacity limit?
I'm not sure I see the necessity for that. I think that a simple nameplate capacity restriction is all that would be required. And that's the standard order condition we've been using in the past. So I think I would need to hear a reason as to why this one would be different and why that would require that.
You've heard the testimony of Mr. Schneider today on the stand?
Yes.
And do you have any reason to disagree with his description of solar projects in general, which indicated that given line losses and other engineering factors, there's always a loss of energy between the generation source and the point of interconnection?
I have no reason to disagree with that.
No further questions.
Okay. Any other cross? Redirect.
Yes, we do have redirect, Your Honor.
Go ahead.
Was engineering analysis presented by the applicant in its application and completed by commission staff, including safety, reliability, and environmental analysis, completed with a 252 megawatt capacity in mind?
Yes.
And did you hear witness Schneider state that the project will be similar to other solar projects that the commission has approved in the past?
Yes.
And did that statement bolster your testimony that standard order conditions are appropriate for this project?
Well, just a minute. My recollection of his testimony, he wasn't speaking the project in projects in Wisconsin. Is that
correct?
That
but he was saying that I believe that there's nothing about this project that's different, that the interaction between the nameplate capacity and the interconnection capacity is something standard that's common to all solar projects.
Right. But he didn't testify directly to projects in Wisconsin. I just want to make sure
That's correct.
Okay.
That's what I meant to ask.
Okay, so I'm sorry.
So my question is, given that the interaction between the nameplate capacity and the interconnection capacity for this project is the same as it is for all solar projects, does that support your position that the standard or condition language that you suggest is appropriate in this docket.
Yes.
Thank you. No further questions.
Your Honor, brief follow-up.
Sure, go ahead.
Mr. Taylor, do you agree that the order points that the commission puts in a CPCN approval should be as accurate as possible in describing the project and allowing it to operate?
Yes.
No further questions.
All right. Any follow-up? Redirect?
No.
No, okay. All right, so I think we have everything from witness Taylor. Thanks very much. You're excused. And anything else from commission staff? That's all staff witnesses, correct? Yes, okay. All right, so I'm gonna turn the screen share off for a bit. I don't think we need that document anymore. And let's see, is there anything else we need to take care of while we're here? No, nothing? Okay, so we will.
Your Honor, it would help.
Yes.
I'm sorry, one thing, if it would help the court reporter, I'm happy to provide the copies of the SIR rebuttal that we read today.
That would be great. Thank you.
Yeah, sure. Why don't you just serve that? So if you're going to be, just email it on to the service list and the court reporter, please. Do you have the court
Thank you.
reporter's email?
I believe I do. Thanks.
Okay. So, and you don't file it on Earth, just serve it to the service list.
Mr. Callisto, I probably have the regular court reporter's email address. I'm just here for the day, so I'm just helping out.
If you could send me your email, I'll send it to you in that broader email. Thank you.
Right.
Okay, great. So I did want to mention we will be back here for the public hearing sessions at 2 p.m. and 6 p.m. Thank you all for joining us here at the party session, but we will take public comments in the afternoon and the evening. At this point, I believe we have everything we need for the party session and we are adjourned. Thanks very much.